Okay, I want to start by thanking everybody for all of your kind comments and words. As an attorney, obviously, it's my job to be on both sides of an issue, and all day at work, I have to look at both sides, potentially argue for my client's benefit from either end. So these videos are an opportunity for me to just look at everything from a state of almost neutrality, so to speak, and just take it from there. And it's much easier. So I appreciate all your comments and all your subscriptions and your kind words. But there's been questions regarding potential appeals, the sentencing situation, and yes, even my issues with the closing argument. So I figured I would just knock them all out in one shot, one last video, and get it over with. So yes, I am working off of notes, but to start, an appeal. Technically, yes, he can take an appeal. You can appeal any adverse ruling that happens during the case. So any objection that was overruled or sustained for the state, any piece of evidence that they wanted to get in that wasn't allowed, anything like that. In the old days, I'm talking even before my time, you used to have to claim it to the judge to alert him of the fact that you were taking an appeal. Now you have a certain period of time from when you first discover the appealable issue to file notice with the appellate court. Do I think he has grounds for an appeal? Yes. I could see a potential appeal on one issue that is a potential, which is the judge's refusal to sequester the jury when the Dante Wright shooting took place, particularly with Maxine Waters giving the statement that she did that resulted in her being censured by the House of Representatives. I could see the defense taking an appeal saying it was prejudicial to our client because the jury could have potentially felt intimidated that if they didn't come back with a guilty verdict, they were going to be, somehow punished. Now, without an actual signed, written, and sworn affidavit from a juror stating that fact, it's highly unlikely that any appellate court would actually overturn the conviction. Does that mean that they can't take the appeal? No. They can, of course, take the appeal. They wouldn't even have to tell us. And I don't know if Eric Nelson would be the attorney to do it or not. He would probably hire an appellate attorney. But I've done appeals. It's not easy. It's not fun. You're in a room with a judge. You have a red, orange, and green light. You have a certain amount of time. Once the light turns red, you're out. And as soon as the light turns on, the judges just start hammering you with questions. There's no jury. There's nobody in the room. You have to convince these judges. You think proof beyond a reasonable doubt's hard? Convincing all these, majority of the judges that you're right and the other guy's wrong, that's difficult. So I think there's a potential appeal there, as well as possibly regarding the state's rebuttal argument, because first of all, it's completely bad form to object during an attorney's closing arguments. Like, we are taught never, ever object to another attorney during closing arguments unless it's so egregious that you just can't. And I personally, during Nelson's closing arguments, felt that the state should have objected. But I'm sure you all saw the look on the state's attorney's face when Nelson objected to his use of the word story the first time. He was like, what? Did I just hear an objection? The judge overruled that objection, but it was later made again by Nelson 2 more times. And the judge sustained it the second 2 times. So technically that first overruled one, if somehow Nelson or the appellate lawyer can say that use of the word story, by being inconsistent with the subsequent rulings, prejudiced him, that could be a potential grounds for appeal. Now, other standard grounds for appeal, there's 2, and ironically, they kind of contradict each other, but one is what's called newly discovered evidence, and let's classify this as a year into Chauvin serving his trial, it comes out that there was actually a witness who was walking down the street prior to the police arriving on the scene, and they witnessed George Floyd down an entire bottle of pills. And the reason why the blood didn't show up in his tox screen was that it didn't have enough time to process into his system. But in fact, there was much higher evidence that he could have been overdosed. And this guy didn't come forward because, whatever, it was a nationwide thing. He didn't want to get involved. But he comes forward a year later. Chauvin could technically bring an appeal on the grounds of newly discovered evidence. And I use this example because this is the baseline floor of what would be considered newly discovered evidence, meaning it could be argued that that's not newly discovered evidence successfully by the state, because they could argue, well, Nelson had investigators. It was on him to go out and canvass the neighborhood and look to see if there were additional witnesses, and could very well be successful on that. So that is like the bottom entry level for that type of an appeal. Ironically, if you lose on that grounds, what someone will usually do, and again, this is all contingent on something coming out later, is they will flip from saying, my attorney did everything he could to try and find that evidence. There was no way he was going to find it. That's newly discovered evidence. You lose on that. You flip it around and you say, my attorney was incompetent. I had ineffective assistance of counsel because he failed to find that evidence when he should have. And you kind of use the appellate court's ruling against them. I've seen it successfully done here in this state in a high-profile case, the Skakel murder case, the Kennedy cousin. He eventually got off doing that exact thing. He argued first newly discovered evidence, he lost, then he flipped it and argued that his lawyer, Mickey Sherman, was ineffective. They granted it and they let him out of jail. So I can't sit here and say that it can't be done, because it can, but it's all hinging on there actually being newly discovered evidence. As it stands right now, the Maxine Waters issue and the failure to sequester after the Dante Wright shooting, if some evidence comes out that the jury in some way felt pressured, could very well be grounds for an appeal, even without the jury feeling pressured. But I would wager that that would be required to prove that as grounds for an appeal. Now, as far as, I'll just briefly touch on my issues with closing arguments. The first issue I had with Nelson's closing arguments was he started off by saying, we can't be intellectually dishonest. And he used the example of Dr. Tobin. And he said it would be intellectually dishonest of me to say, oh, well, Dr. Tobin said that he died of asphyxiation. But then he got up after the CO2 testimony and said that he had 98% blood saturation. But it would be intellectually dishonest of me to argue, well, he can't have died of asphyxiation if he had 98% blood oxygenation, because there were EMTs that testified. They came to the stand and testified they performed an hour of CPR on this man. That reoxygenated his blood. But then Nelson immediately flipped around right after that and was intellectually dishonest and said that they should still consider that as, how could those two things coexist? Because if the EMTs came in and there wasn't CO2 poisoning, actually I wasn't really clear on what Tobin was trying to argue, but what Nelson was trying to argue, but what Tobin was saying was carbon CO1. Carbon monoxide attaches to the hemoglobin in your blood, and it would have never reached 98% if he had CO1 poisoning, because the oxygen from the EMTs breathing into him for the hour plus afterwards wouldn't have been able to knock the CO1 off of his blood hemoglobins, and his oxygenation level would still have been way lower at the hospital. So that I found to be intellectually dishonest by Nelson. But then there was his tirade for hours, and I'm going to get into the CO1 thing because I think, I'll just say it now, that was a grenade, and I'm so glad that the state finally pulled the pin on it, because Nelson had introduced that whole carbon monoxide poisoning when there was no evidence ever admitted that the car was even running. The state brought this up on redirect, and I was so glad they did and pulled the pin, because they also brought up what I was waiting for someone to bring up. Who put his face there? The police. So if he did die of carbon monoxide poisoning, whose fault is it? It's still Chauvin's fault, because he's the one who put him down on the ground next to a presumably running tailpipe. But there was no evidence that the car was even on. That was what the defense's own expert testified to. I don't even understand how he was permitted to bring this up during closing arguments, because there was no evidence of it. And the rule is, you can't argue something that's not in evidence. But that's why you'll notice the judge, right before the state gave their rebuttal arguments, gave the jury an instruction and said, if there's facts or evidence that you heard from counsel that doesn't quite line up with your recollection of the evidence, you are to remember, counsel's argument is not evidence. You're to go with your memory or your notes. That's about as close as you can get to a judge calling you a liar during your closing arguments as you can get without creating an appealable issue. But then Nelson went on for hours. The reason I couldn't make a video about closing arguments until after the verdict came out, about this whole reasonable police officer. And he went through minute by minute, second by second of every decision that was made, except you know where he stopped? He stopped right at the moment that he put his knee on George Floyd's neck, and he never addressed how reasonable it was to stay on his neck. The whole issue of the case was whether or not it was reasonable to remain on him for that length of time. And he stopped his whole reasonable officer speech right at the moment. And he made this point about the crowd that I think the state missed, that I would have made a huge deal out of. The state made part of it. They got halfway there, but they didn't make it fully. He made this issue about, well, wouldn't it have been safe for him to render aid when he found out that there was no pulse? Now, granted, that doesn't mean that he couldn't have just gotten off of him. But putting that aside, wouldn't it have been real? Because there was a crowd and they were getting more and more confrontational, and they were, it was accelerating and they were getting louder, and you saw him pull his mace, which if you were watching, he kind of pulled his mace because someone walked up a couple of steps. And he tried to say that some high school girl surprised him by coming up behind him at the same moment that George Floyd stopped breathing. So the state did a good job in their rebuttal of pointing out that, there was a 9-year-old child or 10-year-old child there. There was some high school students. The clerk was 18, the girl who was bringing the little girl to the store. There was a 61-year-old man. So, with 5 police officers and the people up at the Central who were watching the video camera who had said, nothing had happened for so long, I was worried my monitor was frozen. I banged on it because it was frozen. So, the state said there was no split-second decision-making here. There was no acting reasonable in the heat of the moment because the person said they thought their monitor had frozen because no one was moving. But the other point that he left out that was so obvious to me was he had talked about how he was trained in de-escalating crowds. What was it that the crowd got more and more confrontational about? What was it that you heard the crowd start screaming when they went from just observing to yelling to insulting to calling the police on him? It was when George Floyd passed out, stopped breathing, and people were saying, yo, get off of him, take his pulse, take his pulse. So if he was a truly reasonable police officer and was following his training in de-escalation and crowd control, wouldn't it have been simpler to de-escalate the crowd by getting off of George Floyd and taking his pulse? I thought that was a prime argument the state could have made on redirect, on rebuttal, and that they missed, because that was what was escalating the crowd. So this whole complaint that Nelson was making that the crowd, this crowd of children and high school students and elderly people and, people from all walks of life that never got violent, had no weapons, were getting louder. The whole issue was that he wouldn't get off of him. But it was clear, and this is an opinion and it's opinionated, and I'll admit it, I'll just say this is not fact. He wasn't taking orders from lay people because he was an officer. So there was no way he was getting off of him once they said, get off of him and check his pulse. That cinched that there was no way he was getting off of him. So that and the misstatement of law. And I was worried that this would actually sway the jury when I finished watching it. I almost made a video late at night because the way Nelson brought it up was he made it look like the state had lied about what the law was. He took the jury instruction and he took the last section and said that the state left it off about how all, the proximate cause, the substantial factor must flow from the defendant's actions, and then said, so anything that existed before, that pre-existed my client's actions, like his heart condition, his drug addiction, the drugs in his system, all of this, if you find that any of those were substantial factors, you have to find him innocent. That is a blatant misstatement of the law. There is a legal standard for that. It is called sole proximate cause. It means that the defendant's conduct is the only substantial factor. Now, the state did on redirect address this. I just don't think they cleared it up well enough, and I was concerned because the way he couched it was that the state was trying to hide the ball from the jury, and that if they found any of these other things, he was innocent. No, that's not the way the law works. Sole proximate cause, I had a sole proximate cause case. In Connecticut, if you sue the city or the state for a defective highway condition, you have to prove it by sole proximate cause. We had an intersection where a traffic light had been out for 7 days, 5-way intersection, 5 streets meeting at all crazy angles. Our client's walking along the side of the street. There's no light on at all. The traffic lights are out. The city had been out, had an engineer go out, and there was proof that they had opened the box and closed it, but we didn't know what they did. We couldn't prove what had happened. If they had tried to fix it and couldn't, then they weren't telling us. Our client's walking along. One car comes to the outlight. Another car from another street comes to the outlight. They go together. They collide. One goes off the road, hits our client, pushes his head into a wall, paralyzes him, gives him a traumatic brain injury. We didn't take the case to trial. We settled it in the millions, but we settled it because we didn't want to take on a sole proximate cause case, because anything anything else that could have contributed to, car was going over 25 miles an hour, the posted speed limit, we lose. Driver wasn't paying attention to one of those cars that caused the accident, we lose. That's sole proximate cause. That's the instruction that Nelson gave to the jury. That's what had me so riled up. That was not the standard in this case. In this case, it was just his conduct had to be a proximate cause, a substantial factor. Remember the whole proximate cause versus legal cause. Legal cause was but for Hitler's parents having Hitler, there would have been no Holocaust. Proximate cause in Connecticut and Minnesota apparently is the substantial factor test. All the state had to prove, which obviously they did convince the jury, or the judge did during instructions, cured it well enough, that it just had to be, it didn't even have to be the most substantial factor of George Floyd's death. It just had to be a substantial factor. That was my personal biggest issue, and I felt that the state, who normally is not entitled to appeal acquittals, would have been entitled to an appeal if he had been acquitted or the jury had hung based on that the state could have appealed it. But that was just my opinion. It obviously didn't come to pass. So now we have sentencing. What did we see? The judge had said to the state, is there a motion you want to make? And the state said, yes, Your Honor, we want to revoke his bond. That's simple. I can explain that. He's no longer got the presumption of innocence on his side. Because he's been found guilty, now he's guilty. That's it. So his bond was revoked. The judge ordered what's called a PSI. PSI is a pre-sentencing investigation. It means that probation comes down to the jail. They ask him a bunch of questions from his birth right up until the time of the incident. How he's feeling, about his parents, about his family, about his relationships with people, everything, so that they get as big a picture of his life as possible. They present a copy to the judge, to the state, to the defense, and they use it at sentencing. How does sentencing work? Okay, so there's different amounts of time. There's mandatory minimums, 5-2-1, mandatory maximums, 45, 25, 10. Technically, there's what's called consecutive time. Consecutive time is rare. Could be grounds for an appeal if it's considered an excessive sentence. I should throw that in. That is a potential grounds for appeal, though not usually one. Consecutive time would be he has to do the 45, then the 25, then the 10, meaning he has to do 80 years in jail. That's consecutive jail time. Let's say the judge gives him the max on everything, which I don't think is going to happen. The problem with that is, in order to qualify for parole, he would have to serve the whole 45, the whole 25, and then half of the 10 to be eligible for parole, if they're a 50% parole state. Some states are 75, 85. You'd have to serve whatever percent, but you'd have to get down to that last sentence and do whatever percentage. So he'd have to serve the first 2 sentences first before he could ever be eligible for parole. The second and more commonly accepted way of doing sentencing is, even if the judge gave him 45, 25, 10, he only does 45 because it's what's called concurrent time. While he's serving that 45, he's also simultaneously serving a 25-year sentence and a 10-year sentence. That's how I think the sentencing is going to go. Do I think he's going to get the max? No. Do I think he's going to get the man-min of 5 concurrent with 2 and 1? No. I think he's going to get somewhere in between. My guess would be somewhere between 10 and 20 years he's going to get total when you add it all up, and that it's going to be concurrent. The judge is going to give him somewhere in the middle area on everything, and the top count, the max amount of time he gets on that, that's going to be his true sentence. Everything else is just going to be kind of shuffled in with it. This case, those other 2 charges were really to just set the bar for what the conduct rises to. So in this Dante Wright trial, when it comes up, that jury will be better informed, having seen this trial, obviously, as to how to apply the standards of what amounts to what. So other than that, I think that pretty much covers everything. I mean, I'll double check my my little notes that I made here beforehand. I think I got it all. So I appreciate, again, I just want to say thank you to everybody for your comments. I really appreciate it. I appreciate all the nice things you guys have been saying in the comments to me, and that you're subscribing to my channel. Like I said, I'm not going to ask anybody to subscribe or hit the bell or any of that stuff because it's not my style. This is a release for me to not have to take the legal situation like I do all day while I'm obviously at work, and find a way to fight for my client based on those facts. It's much easier and much more relaxing for me to be able to look at it and say, well, I can see both sides, so let me look at it from both sides. And that's what I'm trying to do here for you guys, is just give you the legal description of what's going on while not taking a side, not advocating for one position or the other. I'm just trying to give you the way I think it's going to shake out based on my experience, what I've seen, and what I'm seeing. So I'll continue to do that per requests of people until somebody tells me, you know what, I'm sick of listening to you, which I figure will happen eventually. But thank you to you all again. I hope everyone's safe and healthy. I hope everyone's doing well. And till the next legal issue comes up, which who knows, could be tomorrow, could be a week from now. I don't know what my next video is going to be on. But I promise you there will be another one. And I thank you all for subscribing and your comments. They've really touched me. Thanks. Take care.